I work at the, oh, we're
Oh,
recording.
oh, we
So
want to stop that. Well, okay.
yeah, we'll talk later.
Okay, that sounds good. Do you want to just try sharing your slides real quick while we
Yeah,
let everybody in here?
I was looking for something here, so let me write it down before I do that.
Yeah, that sounds good. And no rush at all with that.
All right, we want to welcome everyone to the UNM Law and Mental Health series. This is a series that's run by the Division of Forensic Sciences at the University of New Mexico, supported by the Department of Psychiatry and Behavioral Sciences. I'm Jeff Youngren. I'm not Anthony Perillo. I'm the assistant director of the fellowship here. I'm a clinical professor here as well. And take 2 seconds. We're honored to have Candyce Shields be our speaker today, but a couple of little odds and ends. I think that most people know that this program has become a kind of a key source of education on forensics and in mental health practice. And it really exists in many ways as an accident because in COVID, we had the postdoc in place and we couldn't meet together. So someone came up with the idea that maybe we should do our didactics online so that our postdocs could have their didactics. And that idea sounded like a good idea. And then somebody else suggested that let's just put them online for the community to see whether other individuals would like to attend our talks. And then we got the CEs and the CMEs authorized. And so the first presentation of law and mental health had a total of 17 people in it. And the most recent record is a little over 750. So the program has really worked primarily because of people like Candyce who continue to present pro bono to and make this program more and more successful. So I'd like to thank everyone who attends this for making this program so successful for the University of New Mexico. We have a good program here, but it's made good because of this program and the speakers like Candyce who have kind of come in and worked to develop the program. It's only gotten better. If you're pursuing CMEs, a sign-up sheet will be posted shortly by Alex. The APA-CE link will be posted at the end of the presentation. So you need to link onto that, fulfill the questionnaire, and then you will immediately be downloaded your CE certificate from the computer here at the University of New Mexico. If you missed a recent talk by Abigail Tucker, the discussion of active bystanders in law enforcement and correctional settings, it's available now on our YouTube channel. So you just link into it. You won't get CEs for that, but all of our videos are stored away, as will this one be. Candyce has agreed to allow us to put this talk on our YouTube channel. So Let's get back to this week. Let me introduce Candyce Shields. Candyce has presented before for us. She's board certified in forensic psychology, and she's the 2016 recipient of the Distinguished Contributions to Forensic Psychology Award given by the American Academy of Forensic Psychology. A big deal for sure. Dr. Shields has taught many workshops nationally on the topic of evaluating competencies to stand trial and legal insanity. She is an assistant director of evaluative services and forensic psychologist at the Center for Forensic Psychiatry in Michigan, where it's snowing today, I've been informed. It is not snowing in New Mexico, but anyway, and she's an instructor in the Department of Psychiatry in the University of Michigan Medical School. She conducts, supervises forensic mental health assessments relative to criminal competencies and legal insanity in the state of Michigan and the federal jurisdiction. Candyce, on behalf of the University of New Mexico and our program, I thank you very much for being a part of this once again. And now I will disappear and the talk is yours.
Thank you, Dr. Youngren. That was such a kind introduction, and it is so true. There are some flurries in the air here in Michigan today. I want to say hello to my colleagues out there. Good morning to some of you. Good afternoon to others. I hope you enjoy this presentation today. This is a topic that I have become interested in. I think that we can all agree that when we're doing legal insanity cases, I would be hard-pressed to think of a case that didn't involve some sort of concomitant use of substances. So these types of concepts come up in most all of our cases when we're evaluating legal insanity. So in my training and development, moving along and being introduced to the concepts of settled or fixed conditions, settled or fixed insanity, and we'll discuss that intermingling today, I've become very interested in trying to tease this apart, simplify it, and kind of figure out just what's going on. So let's get started with that today. Dr. Youngren went through these things. Just a disclaimer that the views expressed today are those of mine and do not necessarily represent the views, policies, or positions of the University of New Mexico. Here are your learning objectives, which you can read in the advertisement as well. So let's talk about contributions of drugs and alcohol to the commission of crimes. There are three ways in which drugs and or alcohol may contribute to the commission of crimes. Crimes may be committed when a person is intoxicated, either voluntarily or involuntarily, or during which time a condition has become settled or fixed, the informed understanding of which is my goal with today's presentation. In the course of my study of the ensuing concepts of our talk today, I have come to like definitions set forth in Colorado's sanity scheme for intoxication and voluntary and involuntary intoxication. So thank you, Colorado. We're going to be talking about People v. Lowe and People v. Bieber today and looking at your statutes. Let's take a look now. For intoxication, we have from Colorado's criminal code, a disturbance of mental or physical capacities resulting from the introduction of any substance into the body. That's important. We're talking about any substance, whether it's a substance of abuse or a substance that's not normally or typically thought of being abused. Voluntary intoxication is caused by substances which the defendant knows or ought to know have the tendency to cause intoxication and which he knowingly introduced or allowed to be introduced into his body. Voluntary intoxication is also referred to self-induced intoxication. That makes sense, where a person knowingly ingests a substance known to cause or potentially cause intoxication. The voluntary modifies the intoxication, suggesting that a person understands that ingestion of a substance will possibly produce a state of intoxication. Therefore, a person voluntarily enters into this contract, so to speak, when introducing a substance into their body. Voluntary intoxication typically does not excuse people from responsibility. However, with just about anything, there are caveats. And a couple of caveats are that some states allow voluntary intoxication to negate the requisite mens rea in specific intent crimes. And some states allow significant voluntary intoxication to negate a required element of the offense. The Supreme Court of the United States has ruled that the Constitution does not require states to consider a voluntary intoxication defense to determine whether an individual possessed the requisite mens rea in a specific intent crime. SCOTUS's analysis relied heavily on a survey of historical practice and precedent in the states. And they summarized that, quote, not every widespread experiment with the procedural rule favorable to the criminal defendants establishes a fundamental principle of justice, end quote. And this is set forth in Montana v. Egelhoff. Involuntary intoxication is intoxication that is not self-induced, and by definition occurs when the defendant does not knowingly ingest an intoxicating substance or ingests a substance not known to be an intoxicant. With respect to involuntary intoxication, a person does not know that they ingested a substance, or if they did knowingly ingest a substance, they do not expect it to cause intoxication. Again, involuntary modifies the intoxication, not how the substance was necessarily introduced into the body. With involuntary intoxication, a person may not know they have ingested a substance. However, it can be the case that they knowingly ingest a substance, for example, a legally prescribed medication, and they become intoxicated, not expecting intoxication to occur. Involuntary intoxication is when a person is not to blame for becoming intoxicated. Consequently, involuntary intoxication may constitute a qualifying threshold condition under some jurisdictional provisions for legal insanity. So here are some forms of involuntary intoxication, where ingestion of drugs is prescribed by a doctor and taken pursuant to a prescription, ingestion of a substance by mistake, being roofied, or the Mickey Finn defense, coerced intoxication, intoxication that is involuntarily induced by reason of duress or coercion, and then pathological intoxication, which still makes me scratch my head today, but I think the Model Penal Code kind of says it best for me, that it's intoxication grossly excessive in degree, given the amount of the intoxicant to which the actor does not know he is susceptible. Involuntary intoxication was referenced as early as 1847, when Lord Hale wrote of and accepted the concept of involuntary intoxication as an excuse to criminal responsibility. Regarding involuntary intoxication, Lord Hale wrote, and bear with me, give me grace, because I don't speak like this, so to talk like this is a little difficult, but he wrote that if a person, by the unskillfulness of his physician, or by the contrivance of his enemies, eat or drink such a thing as causeth such a temporary or permanent frenzy as aconitum or nux vomica, this puts him into the same condition in reference to crimes as any other frenzy, and equally excuseth him. If you're wondering what aconitum and nux vomica refer to, aconitum, and maybe I'm butchering that, it's a genus of poisonous flowering plants or herbs. It's part of the buttercup family. And nux vomica in Latin means vomiting nut. It's an extract of the seeds of the strychnine tree, which is a spiny Asian tree with orange fruit and toxic seeds. It's used in traditional and homeopathic medicines. So that was very fancy by Lord Hale. Involuntary intoxication, in order to establish this with respect to a prescription, a defendant must not know or have reason to know that the prescribed drug is likely to have the intoxicating effect. I will use a drug that has come up in consultations that I have done in the past, prednisone. A defendant takes prednisone and does not expect this to have an intoxicating or psychotic effect. And I've seen this happen. You must also make sure, or the trier of fact will question, whether or not another intoxicant the prescribed drug and not another intoxicant, must have caused the intoxicated condition. A defendant must prove the medication was also being taken as prescribed. I know in some jurisdictional case law in my jurisdiction, this has come up. However, it was proven that the defendant, even though they didn't know they were going to become intoxicated with the prescription drug that they had taken, they weren't taking it as prescribed. So that's a whole other issue. Still, to establish legal insanity, and I want to continue to emphasize this, the defendant must establish that as a result of the intoxication, he or she was rendered insane by a jurisdictional standard. Therefore, the effect of the intoxication must be assessed in conjunction with the test for legal insanity. The intoxication must meet criteria for a jurisdiction's threshold mental state, that is, a mental illness or mental disease or defect, whatever your threshold condition is in your jurisdiction, and as a result, criteria for a jurisdiction's legal insanity test. Let's now discuss settled and fixed conditions, since we now have an understanding of voluntary intoxication, mostly, which is highly relevant to conceptualizing these two concepts. Some courts have recognized that mental disease or disorder caused by the ingestion of substances is a basis for a defense of legal insanity, potentially exculpating a defendant from responsibility. However, federal and state courts vary widely regarding whether they allow consideration of or under what conditions the ingestion of substances to constitute a qualifying threshold condition necessary for defense of legal insanity. SCOTUS has never addressed whether there is a due process right to a defense based on a settled or fixed condition, or the implications of denying such a defense. SCOTUS had the chance to consider the matter, but denied cert in the case of Bieber v. People out of Colorado in 1993, where Colorado's Supreme Court held such a defense is invalid. So here are some jurisdictions having accepted an insanity defense predicated on a settled or fixed condition. I acknowledge that the designated list on this and the next slide may be incorrect. I'm just going to give it up. In my perusal of the literature, and without researching each and every state or the noted cases or law, this is the best that I have come up with to date. I say this as I am aware that some reports are incorrect. For example, in Bieber v. People, this case out of Colorado provides a list of cases purported to recognize the doctrine of settled insanity as a defense. However, the case noted for Michigan is incorrectly noted to be People v. Cawley, when in fact the seminal case is People v. Conrad. Therefore, I acknowledge the potential for inaccuracy in this list or the next. What I do know is, as of 1998, and hopefully many of you out there were born as of that date, but as of that date, 30 states and jurisdictions, including the District of Columbia, had encountered the defense of settled insanity. 29 out of the 30 accepted the defense. That is, 97% of the encounters had been accepted as of 1998. And I know that that's a while back. However, that means that settled insanity was accepted law in only 29 out of 50 states, or 58% of states, as of 1998. It seems high time for an update, and maybe this will be my next endeavor that I take up in my free time. I say that a lot. Felix and Wolber indicate that Connecticut and Delaware have since rejected and joined Colorado, rejecting the doctrine of settled insanity. This is also cited in a reference Carter Yamauchi in 1998, and Levine, also 1998. And you'll have those references at the end of my presentation today. With respect to settled in fixed conditions, this is possibly the most perplexing point right here, the problem of a definition. I assert to propose unifying definitions for what constitutes a settled or fixed condition at the end of today's presentation. Before doing so, however, let's review the foundation upon which my proposals are made. To date, according to my study of these concepts, no uniform standard or definition exists for what settled means to guide evaluators in determining whether a condition meets any agreed upon criteria. Settled condition and settled insanity are also used interchangeably throughout the existing literature, such as sanity was once synonymously used in early case law to refer to competence to proceed at the time of trial. I have also found that the intermingling and application of the terms temporary and permanent in the context of discussions about intoxication and legal insanity further perpetuate confusion and miscommunication in defining what is meant by the terms settled or fixed. For clarity and ease of understanding, the factor to be determined is whether a mental condition at the time of the commission of a crime is settled to the extent it qualifies as a threshold condition. That is, a mental disease or defect or subsequent determination of legal insanity. Therefore, we are talking about settled conditions. Words are important, so we need to be uniform and thoughtful in our choices to convey the correct meanings. The next few slides will demonstrate the multitude of conceptualizations or definements of what is meant by settled. As noted earlier with involuntary intoxication, fixed or settled conditions were seemingly recognized as early as 1847 by Lord Hale as well. He wrote, that although the simplex frenzy occasioned immediately by drunkenness, excused not in criminals, yet if by one or more such practices, an habitual or fixed frenzy be caused, though this madness was contracted by the vice and will of the party, yet this habitual and fixed frenzy thereby caused puts the man into the same condition in relation to crimes as if the same were contracted involuntarily at first. Breaking down Lord Hale's intentions, simplex frenzy occasioned immediately by drunkenness equates to voluntary intoxication and does not excuse criminal conduct. On the other hand, a habitual or fixed frenzy equating to a settled or fixed condition may excuse criminal conduct in the same way as an involuntarily derived intoxication. Judge Orth, in delivering the opinion for the court in the Maryland appellate case of Parker v. State, realized that the distinctions need not be made between the language of temporary or permanent insanity, but rather should focus on the outcomes or effects of substance use, some being direct and sought after, as in voluntary intoxication, and others being remote and undesired, as in a settled or even fixed condition. In Parker v. State, it is written, what permanent, fixed, or settled means within the frame of reference is that the insanity not only existed while a person was under the influence of intoxicating spirits as an immediate result of imbibing, but existed independent of such influence, even though the insanity was caused by past imbibing. I might agree with Justice Orth's summary of the terminology if he had worded it slightly differently by stating that what permanent, fixed, or settled means within the frame of reference is that the condition existed independent of the influence of the intoxicating spirits, even though the condition was caused by past imbibing. So substituting insanity with condition. Highlighting the reference to temporary and permanent, and substituting, as I just stated, insanity with conditions, per the opinion of the appellate court in Parker v. State, it would seem that the distinction is not so much between temporary or permanent, as it is one between the direct results of ingesting a substance, which are voluntarily sought after, and the remote and undesired consequences, which, as we will come to find out, is a settled or fixed condition. Oops. In the seminal case of People v. Kelly, the California Supreme Court defined voluntary intoxication as situations in which mental impairment does not extend beyond the period of intoxication. Makes sense. They define long continued intoxication as the mental disorder remains even after the effects of the drugs or alcohol have worn off. Well, I'm here to say that is a settled condition. So it's also known as a settled condition. They just didn't call it that at that time. And People v. Kelly, the California Supreme Court wrote, we have repeatedly held that when insanity is the result of long continued intoxication, it affects responsibility in the same way as insanity, which has been produced by any other cause. In this case, the court ruled that a psychosis brought about by the involuntary drug ingestion need not be permanent, but settled, meaning the psychosis continued past the period of intoxication. In the Kelly case, there was evidence the psychosis lasted many months beyond the intoxication. In People v. Kelly, the California Supreme Court wrote, the trial court made a compound finding that Ms. Kelly's insanity was not of a settled and permanent nature. However, we have pointed out that insanity need not be permanent in order to establish a defense. My point regarding the intermingling of terms is made in deciphering statements made by the California Supreme Court in this seminal case of People v. Kelly from 1973. By their confounding the full gestalt of legal insanity when they could have been focused on determinations to be made in the sum of the parts constituting legal insanity. Specifically here, a threshold condition. The trial court made a compound finding that Ms. Kelly's condition was not of a settled and permanent nature. However, we have pointed out that a condition need not be permanent in order to establish a defense. If we substitute the occasions of insanity with condition in the Supreme Court statement, the conceptualization is more meaningful. For what the California Supreme Court referred to in the second half of their statement was the full gestalt of legal insanity, which they established as needing not be permanent. I have a beautiful flowering plant that is bringing about some friends in my face. Sorry about that. Okay. In another California case, but an appellate case from 1986, People v. Skinner, criteria were promulgated for what constitutes a settled condition. And here they are, that the qualifying condition must be fixed and stable, last for a reasonable duration, not be solely dependent upon the ingestion and duration of the intoxicating effects of a substance. In the Colorado case, again, of People v. Bieber, Justice Lohr, in his dissenting opinion, wrote, settled does not mean permanent or incurable, but means that the mental disease or defect exists independently of the contemporaneous use of the drug. Here, we still have judges confounding terminology by maintaining long-term consumption. Nevertheless, I can get on board with this terminology in relation to defining a fixed condition. Justice Lohr did also write, and I agree, quote, the proper focus is on when the drugs or alcohol were ingested in time relationship to the criminal offense. Referring to fixed or settled conditions, Levine or Levine, I'm not sure how that's said, wrote, when long-term consistent use of substances results in disorders symptomatically or organically similar to mental disorders. This definition comes from a law review that was published in early 1998. Many distinctions have been made, and the definitions of fixed and settled insanity have changed and evolved over the past 25 plus years. Again, Levine maintains terminology like long-term and consistent use of substances. I feel that what Levine has defined here is more in tune with a fixed condition. I want to briefly acknowledge diagnoses in relation to settled and fixed conditions. I recognize that some of you practice in jurisdictions where formal diagnoses are required in evaluations relative to legal insanity. That is not required in my jurisdiction. However, I appreciate that you will have to contend with that matter. However, time does not lend itself today for a deep dive into possible diagnostic categorizations for the particular threshold conditions we are discussing and describing. However, I will make mention of the two categories of disorders: substance use disorders and substance-induced disorders, wherein are further delineated intoxication, withdrawal, and other substance-induced mental disorders, such as a substance-induced psychotic disorder, etc. The challenge for evaluating, let me start over. The challenge for the evaluating clinician is not so much to determine an exact diagnosis or origin of any substance-related psychotic symptoms, as it is to determine whether these symptoms are more settled and not just the result of acute intoxication. As of today, I couldn't agree more. Having to determine an exact diagnosis or whether psychotic symptoms were drug or alcohol related may make the evaluation task more difficult than it has to be. I have this mantra: keep it simple. So a focus on separating the diagnoses and then attempting to make a connection between drug or alcohol use and psychotic symptoms could obscure the main point. The main point or focus being whether the symptoms manifested at the time of the crime met criteria for your statutory threshold condition in relation to your standard for legal insanity. And it is conceivable that despite the presence of psychotic symptoms, the symptoms have no or little relationship to the criminal conduct in question. The difficulty lies in determining when a condition caused by voluntary ingestion of substances, including continued long-term use, is settled or fixed. Bingo. That is it right there. Again, today, I could not agree more. Some courts or jurisdictions, mine included, make a distinction between the two types and have ruled on both sets of circumstances. That is a settled or fixed condition. Many don't, and the terms are used seemingly interchangeably. In assessing conditions, consider the cumulative effects of repeated intoxications, such as in a substance-induced neurocognitive disorder or a dementia, or a Korsakoff psychosis or syndrome. What about psychosis brought about by substance use, but that continues beyond what would be expected for a period of intoxication for that substance? This is a substance-induced psychotic disorder. And also consider impairment resulting from cessation of a substance or withdrawal. Think about delirium tremens. I have also consulted with a colleague on this type of case, where a person was in the throes of a delirium tremens and committed an assault. If you want more information about whether or not, or how to think about or conceptualize whether that would constitute such a threshold condition, I really encourage you to read Parker v. State. I really enjoy that case, and I've read through it several times. It gives a great history, so I'll recommend that. Here are the various mechanisms of symptom manifestations for settled or fixed conditions. Symptoms can be induced, they can be precipitated, or they can emerge simultaneously to the ingestion of a drug or alcohol. The relevant assessment is whether the symptoms persisted beyond the period that intoxicating effects of drugs or alcohol would be expected. Okay? So noted at the outset of today's presentation, I aspired to propose unifying definitions for settled and fixed conditions. Here they are. For settled condition, I propose the definition being when substance use induces or exacerbates a condition, typically a psychosis, that becomes distinct and independent from the contemporaneous effects of an acute intoxication from the substance. It is my belief that my proposed unifying and working definition of settled condition accomplishes the following. One, it takes into account that we are referring only to a qualifying condition and not the entirety of an insanity determination. Two, it can be applied to the legally relevant time frame, that is, the time of the commission of a crime. And three, it encompasses the remote, undesired, and indirect consequences of a voluntary intoxication. And four, it implies that impairment extends beyond the period of intoxication reasonably expected for a substance or substances. And for fixed conditions, I propose a definition of persistent damage resultant from the cumulative effects of prolonged substance use. Similar to settled condition, this is my proposed unifying and working definition of a fixed condition. Okay? So while we're letting that sink in, now let's pivot and move from conceptualizing now to practical applications. I never like to really kind of give a teaching without giving some practical applications. So here we go. The next several slides contain considerations when assessing the prospect of a settled or fixed condition in relation to evaluations relative to legal insanity. First and foremost, I feel it is most important to do exactly what this slide states. The most important piece is obtaining the most detailed description of the defendant's presentation at the time of the commission of the offense, which includes an outline of the timeline of the onset, the duration, and the cessation of signs or symptoms manifested by a defendant surrounding the commission of the offense or offenses. Get a detailed timeline for the onset, duration, and cessation of the use of substances in relation to the commission of the offense or offenses. And that is what substances were ingested. Usually it's not one, it could be alcohol and other drugs. We need to know how much, we need to know when did they start ingesting the substance, when did they cease ingesting the substance, how, we know that there are differences in the route or method of ingestion, getting the best that we can. And we know that these are extremely imperfect and limited considerations or details that we generally get. These considerations are questions that may guide your conceptualizations and opinion formations. What do collateral sources indicate or say? What do witness or law enforcement statements say? I recently had a case where there was a description by the booking officer of pinpoint pupils. So that speaks to a sign or potential symptom. What are the results of blood, breath, or urine tests? If you have them, these are often absent. I understand that. However, you may have them. And what are other crime scene data or information that could substantiate, support whatever opinion you are drawing or conclusion? What signs, symptoms were manifest at the time of the crime that would meet criteria for your jurisdiction's threshold condition, regardless of diagnosis or etiology? What is the timing of the onset of the signs or symptoms in relation to the ingestion of the substances? Were psychotic signs or symptoms manifest only during the expected period of intoxication, or did they persist beyond the period typically associated with intoxication from the substance? And I'm not here today to go through half-lives and typical periods of each substance for what's considered an intoxicating time period. But did the psychotic symptoms persist beyond intoxication, beyond detoxification? Are the signs and symptoms consistent or inconsistent with those typically associated with the ingested substance? A case that I just completed recently involved several different substances. And I really had to take a look at the manifestations, the signs and symptoms that were manifesting themselves and conceptualizing, well, they really don't go with this type of substance. However, they could be a sign that they had used this substance. Or ask yourself the same thing about whether or not they're consistent or inconsistent with a psychiatric condition. Was psychotropic intervention necessary to ameliorate the manifest condition? Does the defendant have a prior history of psychiatric symptoms or episodes? Or is this a first time psychotic type of break in their, more in the age of their 50s or 60s? This isn't a maybe first psychotic break, say in their late teens, early 20s, or even 30s. Do we have any data to support prior episodes? What do those episodes look like from a psychiatric standpoint, or if the person has a long-standing, or whether or not it's long-standing or not, what is their history of substance use, and how do their intoxicated episodes, or what do those look like? Were symptoms manifest at the time of the commission of the offense consistent or inconsistent with past known manifestations of psychiatric symptoms or episodes, or past intoxications? Is there evidence of psychotic symptoms or episodes before or at other times? I touched on this. To what extent would the defendant's mental condition have been impaired or altered if intoxication was excluded? Was there any sort of data to suggest that this person had started to develop or manifest a psychosis and then also had imbibed or ingested substances, which then exacerbated that condition, and then, of course, lasted beyond a period of intoxication? Would the altered mental condition have occurred regardless of the ingested substances? Another thing, I don't know if I've noted, but it's just come to my head, is that we also need to make sure that the commission of the crime occurs during this period of the settled condition. If the crime is occurring outside that settled period, then of course, there's no consideration. Many of the jurisdictional rulings discussed today aptly emphasize that although a threshold condition is met via a bona fide settled or fixed condition, an accused must still meet statutory criteria, that is, the jurisdictional standard or legal definition for legal insanity at the time of the commission of a crime. So from Michigan's kind of seminal case on settled conditions, People v. Conrad, Justice Brennan, in his dissenting opinion, writes, under these definitions, one must be mentally ill before he can be found insane. But the converse is not true. And that is true. Felix and Wolber, also in a 2007 paper, remind us that it is possible for a person to have a psychotic reaction to drug use with psychotic symptoms that are unrelated to the behavior that's involved in the crime or related in such a manner that an insanity defense is not supported. And that's kind of the point that I was getting at just a few seconds ago. Okay, so you must first determine that a threshold condition of mental illness, disease, or defect, that is, more than simple intoxication, was present at the time of the commission of a crime. And then determine if the threshold condition resulted in the accused meeting a jurisdictional standard for legal insanity. I want to emphasize that the commission of the crime must also have occurred in the settled period, as I did a few slides ago, and not during the expected period of intoxication from whatever substance had been ingested. I also want to note and acknowledge that rarely, even though I am emphasizing getting timelines, that these timelines and facts are completely clear to evaluators. So conclusions are drawn generally based on the likelihood of the presence of a settled condition. So don't be fearful to lay out alternative hypotheses, note limitations, show your work, so to speak, note your considerations, note your recommendations, particularly in these types of opinions and conclusions. So we have a couple slides with references, and that I want to thank everyone for your attention, and I'll turn it back over to Dr. Youngren to field some questions.
Thank you, Candice. Appreciate it very much. We do have a number of questions. We're not going to be able to get to all of them. That's usually the case. We do have the posting for the CEs, and it'll also be posted in the chat box as well. So I'm going to take these in the order that they arrived here. First question, have you come across a single reference for a comprehensive list of medications and substances known to produce the conditions for insanity?
Oh, wow. The short answer is no. Because partly, I don't think a list such as that exists. I was quite shocked, actually, and I brought this up in my presentation when I first came upon with a colleague taking a look at the effects of an adverse effect to prednisone, which is a steroid. So, I mean, I think it has to do with, and I'm not a medical doctor, but it has to do with body chemistry and, any chemical, any drug, or intoxicant is going to produce a different effect in any one person. So the short answer is no, and those are some thoughts that I have on that.
Okay, thank you. Another question, is there any danger to softening legal language as you propose to do, i.e. by changing the word insanity to condition? Maybe if we use softer language, it applies to so many more people than the system, and then the system is overwhelmed.
I'm not quite sure what I am doing is softening the language per se. What I am proposing is that I am putting the focus on the relevant piece of the language. We're not talking about addressing the full gestalt of legal insanity when we're assessing the actual present condition at the time of the commission of a crime. Let's take settled condition or fixed condition out of the mix. In legal insanity, you would first assess whether or not there is a qualifying threshold condition, not a qualifying threshold insanity, because that's what the first part, and then as a result of that qualifying mental threshold condition, does it meet the legal standard for insanity? So that's what I'm trying to parse out, that we don't kind of swallow it whole by continuing to use this language of settled insanity. Well, what we're really referring to is the threshold mental condition, therefore a settled or fixed condition. I hope that's helpful.
Thank you. Yes. As a forensic psychologist, would you feel there is a need to consult with medical specialists on insanity cases where medications or substances are involved with the insanity defense?
If you have the availability, absolutely. I am blessed in that I work with a cadre of highly qualified psychiatrists. They're right in my backyard, so to speak. And thinking of this case that I just recently did, not only did I consult with another forensic psychologist colleague, I also consulted with a forensic psychiatrist who has specialization in addiction medicine. And so, absolutely, if you have the opportunity to do that, I mean, is it always necessary? I'm not going to go out and say that it is. I can often look up, I have references where I can discover some of the information or data that I need to draw a conclusion. But I always welcome the opportunity to be able to consult with a medical colleague when I feel it's necessary.
Okay, a couple more questions. We're getting close to the end of the hour. Question, my understanding is that defendants with a settled or fixed condition do not need to have been intoxicated at the time of the offense. Is that correct?
Dr. Youngren, can you repeat that?
Sure, I got to go back to it though. Sorry.
Oh, sorry.
That's all right. No problem. My understanding is that defendants with a settled or fixed condition do not need to have been intoxicated at the time of the offense. Is that correct?
Okay. So I want to be careful how I say this. I'm going to say the short answer to that. I agree, yes, that an intoxication comes and the settled condition comes later, and that condition that persists is the settled type of condition, and that is when the crime is committed. I think that's what you're getting at, and I would agree.
Okay. Do you look for a history of any psych disorder or just psychotic disorder episode history, OCD, ADHD, depression, or just psychotic symptoms?
Well, I would look for it all because it's my job to look at the foundation of any sort of historical mental health history, and not just relying on maybe others' diagnoses, taking a look at how those conditions may develop and how they may have contributed to a burgeoning psychosis. But I mean, typically, I think what we're talking about are psychotic conditions. However, again, and I like this, I don't have to focus in on a particular diagnosis in my jurisdiction. But we know that, say, a diagnosis of a major depressive disorder with psychotic features, those psychotic features would be something that could be brought about by maybe substance use.
Right.
So if you're looking at it diagnostically, yes, it doesn't necessarily have to be a psychotic spectrum disorder. I hope that answers that question.
Yes.
But I take all of that into account.
Well, we are at the top of the hour. Candice, we're going to draw this to a close.
Great.
Couldn't get to all of the questions, but personally, I want to thank you very much for being a part of our program once again.
Thank you for having
we abuse
me.
our friends, so we take advantage of our relationships, and we hope to have you come back in the future as well. So
I'd be honored. Thank you.
thank you. Thank you to everyone that attended.